I recently made a video where I argued that James King made an error by coming to the Supreme Court looking for justice rather than demanding something that the Supreme Court is actually required to provide, due process. And I couldn't help but kind of begin to think about what that alternate petition would actually look like. And so to start, here's how a statement requiring or demanding due process rather than justice would open. King would have said, plaintiff cannot be deprived of federal process rights without notice that a hearing on that effect is taking place. King had a hearing in district court, but he wasn't given clear notice that it was a hearing on whether he had waived his constitutional rights. So it wasn't until after the appeals court changed their case law or something, and this is according to King. I don't know all the details, but King is saying that it wasn't until the appeals court spoke that it changed the effect of what was even being heard in the district court. And so, in other words, he went into the district court having been given incorrect or ambiguous notice of what issue was even being decided in that hearing. And judge-friendly basic principles of due process say, you can't deprive somebody of his constitutional rights, his constitutional right to process, regulate, and police in this case, without telling him that that's the issue being heard in the district court. He didn't know that issue was being heard, obviously, and whether that's because inadequate notice or his own error, I can't personally vouch for. But that would change the question presented then to, does due process require the effect of a hearing be nullified when courts give inadequate notice of the issue being heard and decided, including the possible forfeiture of constitutional rights? So put simply is, can a court have a hearing that's going to deprive King of his federal rights to due process without telling him that that's what's being heard? And the answer would seem to be obviously no. And so the Supreme Court, in order for the lower courts to provide due process, would have to remedy that with 60b-6. And then the provision involved in the petition for certiorari would be changed from 60b-6 to Milliken v. Meyer, reasonably calculated to give him actual notice of the proceedings and an opportunity to be heard. And then the rest of the statement, or the rest of the opening part of the statement, here's how I would change that. So King starts out by saying, the government has spent more than a decade evading accountability for the unconstitutional actions of two state federal task force members. They haven't been evading accountability. What they've been evading is judicial process. So I would change that to, the government has spent more than a decade evading hearing, the jurisdiction of federal courts to enforce process rights, and King's unambiguous right to judicial regulation of police, which right cannot itself be forfeited by a simple congressional majority or without due process using tricks. So it's not just, Congress can't just say, we're taking away the federal right that, Bivens or whatever. There has to be a hearing for King to lose that right, and he has to be given notice that that's a hearing on. And he would argue that he wasn't. So the current petition goes on. In 2014, these plainclothes officers misidentified, beat, and hospitalized innocent college student. I would change that to, in 2014, these plainclothes officers injured the plaintiff outside their delegated authority without mandatory judicial regulation. Because what he has a right to is due process. There is no justice. Like, he's saying, I want justice that we've decided socially. So we're deciding socially. I'm telling you that this is unjust. Well, he doesn't have a right for courts to provide him what he and other people politically think is justice. He has a right to courts providing due process, which process then itself determines what is justice. They can't just say, okay, we're just gonna shape the whole process by these external political factors to make sure we get a process that produces what the political process thinks is justice. No, what is justice is determined by the process itself. what the process is isn't determined by what you and I think is justice. And then the current petition goes on to say, unless this court steps in to ensure that Rule 60b-6 can accomplish justice, King's story will end in its miscarriage. The Supreme Court cannot cure injustice unless there's a legal error. Injustice is not itself a legal error. The Constitution does not say there shall be no injustice, because that doesn't create a process or a way to determine what's injustice or anything. So that should be changed from justice to process. And it should say, unless this court steps in again to ensure that the facts of this case are measured against plaintiff's right to judicial regulation and relief, King's story will end with his process rights created by legislators being repealed by the ambiguous notice, equivocation, and nebulous procedural roadmap delivered by courts. So courts didn't deliver injustice. Courts delivered inadequate process to fulfill what the legislature demanded courts provide. And then the current petition statement goes on to say, Rule 60b-6 is a procedural device designed to provide relief in exactly the kind of unjust circumstances that occurred in connection with King's appeal. I sure hope that's not true. I sure hope that 60b-6 doesn't allow judges to just say, well, anytime I think that a case outcome is unjust, according to my own judgment, I can just ignore the law and do what the hell I want. I hope that's not what 60b-6 was designed for. So I would instead say Rule 60b-6 is a procedural device that must provide the remedy plaintiff has a right to when lack of notice and court's own confusion would otherwise inadequately guarantee the judicial process reviewing police action designed by the Constitution. That is what the Supreme Court is required to deliver, and it's an error when a lower court doesn't deliver that. The remedy plaintiff has a right to when lack of notice and court's own confusion inadequately guarantee the judicial process reviewing police action designed by the Constitution, not when a court fails to use 60b-6 to override law and process to provide justice. So again, the whole point is that King should have come to the Supreme Court asking for due process, not justice.